Welcome to the Law, Your Money and You. I'm Roberta Saphire, an attorney in Sharon, Massachusetts, New England.
Hi, and welcome again. I'm Camille Barron, and I am a healthcare advisor and financial coordinator, also in Sharon, Massachusetts, New England, USA, world. And so today we have another guest who's been with us before, and we're going to talk a little bit about some of the legal issues that people have started to think about a little more during this pandemic.
Yes, and we are so fortunate to have an attorney who really knows his stuff. Of course, all of our attorneys know their stuff, but this one is so well spoken and so knowledgeable. And we welcome you back, Attorney Barry Crimmins from Stoughton. And he's an expert in elder law and other laws too. Barry, welcome back. Tell us a little bit about yourself again, and
Sure.
We'll get right into this.
Okay, great. Thank you, Roberta. Thank you, Camille, for having me back. It's always a pleasure to see both of you and join in on the program. Yeah, I am an estate planning and elder law attorney. I've been practicing in the South Shore in those areas for over 30 years now. And I very much enjoy these opportunities to come on programs like this to try to educate your viewers about issues that are important to them and are timely, particularly during these very difficult times that we are all going through.
Oh, okay. Well, that's fantastic. You know, I remember when you were on the last time, you spoke about your wife being with the Stoughton Visiting Nurses Association and
Correct.
finding people. Has she relayed to you any differences since because when you were on, it was right when the coronavirus, I don't even think it had started, or it was just about.
No, I was on with you last year. So that was, we met in the
Yeah.
studio, and obviously the viewers can see we're not in the studio today. We're doing this remotely by Zoom. But yeah, my wife is a registered nurse. She works for the Stoughton Visiting Nurses and Public Health Association, which is a public agency of the town of Stoughton. It is located in the town hall, but she is the public health nurse for the agency as well. So she has been immersed in the coronavirus epidemic since its inception back in March, and she has to follow up on any reported positive cases that come out of Stoughton. So she has been very busy during this whole time period.
Does she go out and see any patients?
She doesn't in her current role, Camille. She used to. Occasionally she will fill in and see patients, but presently with her role as the public health nurse, and she's the assistant administrator for the agency, so she's inside now, but still does have occasion where she will fill in on vacations and occasionally on weekends and things of that nature.
Right. So she's probably more involved in setting policy and those sorts of things.
Yeah, some policy decisions, but a lot of stuff during the last several months with the coronavirus and the follow-up required with that. Working closely with Massachusetts Department of Public Health and working with the local nursing homes and hospitals and all of that.
I see. Interesting. So when it comes to your field, which is law, and particularly elder law and estate planning, talk to us a little bit about some of the changes. What are some of the things that have emerged out of this coronavirus that may be a little different than prior to that happening?
Right. So certainly, the pandemic, has had a lot of ramifications. Obviously, in terms of folks' health, unfortunately, many folks have died from complications from the coronavirus. One thing I think that it has caused, which we might refer to as a silver lining, is it has gotten people more attentive to their estate planning needs to wanting to make sure they take steps to get their affairs in order, whether that's preparing wills, preparing healthcare proxies, powers of attorney, living wills, typical estate plan documents. So we have been very busy during this period, both with existing clients, but with new clients as well, who are reaching out to try to get their affairs in order as far as their estate plans are concerned, whether it's updating existing plans or whether it's creating new plans if they've never had one done before.
Yeah, so
Are there more new ones than older ones coming to you? Like
it's a little of both, Roberta. We get a lot of calls from our, as I said, I've been practicing now for over 30 years. So if you think about it, somebody that might have had an estate plan done 10, 15 years ago, chances are they've had a change in their circumstances. That could be changes in their financial situation, changes in their family situation, new children, new grandchildren, whatever the case may be. And so very often we get calls from those clients, and we follow up with those clients ourselves to see if there have been changes that might necessitate the need for an updating of their estate plan. Then, of course, it's the new clients who maybe find out about us from shows like this or from other media and contact us to have their estate plans done. What from a practical standpoint, as we were discussing a little bit before we came on the air, is all this new technology that has come out or has become more popular as a result of this, because many of our meetings, particularly during the early stages, the first few months, March, April, May, many of our meetings were being done through Zoom and other technologies such as Zoom, as opposed to clients coming into the office. Now I think we're finding clients are a little more comfortable about coming into the office. We still practice, proper protocols, face masks, disinfecting the office, all of those things. But clients do seem to be a little more receptive and comfortable about coming in. Those that still have a concern, we have the ability to meet just like we're doing here, as if you two were my clients and we were talking about putting together an estate plan. We do it just like this over a Zoom call.
That's interesting. I did, talking about changes in circumstances, I have a question. Actually, it's from Becca, who knows different people. You have a husband and wife, which is probably these people that you might have done something for 15, 20 years ago. So the spouse either died or they got divorced. The husband and wife are now in a second marriage, and each have their own children. Who even knows they may also have children together? How do they ensure that their children get the respective assets of each other? That's a loaded question.
Yeah, it raises a lot of different issues, a lot of very important issues. Second marriages are very common with our clients, just the sort of scenario you described. Sometimes it's a second marriage for both spouses. Sometimes it's a second marriage for one. In those cases, very often they have children from a prior marriage. And so that raises a lot of questions that require kind of doing the deep dive, as they say, to determine just what exactly the client's wishes are. Contrasted with if you have a situation where you have a husband and wife, first marriage, and they have children, typically when we're talking to those clients and we say, so how would you like to have your assets distributed? And the typical scenario is husband will say, well, I want to leave everything to my wife if she survives me, if not to our children. And the wife's will say pretty much the same thing. I want to leave everything to my husband if he survives me, if not to our children. In the case of a second marriage, where there are children from a prior marriage, it may not necessarily be the wishes of the clients that everything go to the spouse, because it may result in a situation whereby their children could potentially be cut off. So there, it requires a little more creative drafting with the documents, and more communication with the clients, just to make sure we first and foremost identify what their wishes are, and then make sure we draft properly to make sure we're addressing those wishes properly in the documents.
Yeah, 'cause
Would that even be an issue, Barry, if in the previous example where someone, the spouse outlives the other, what if the spouse then remarries? Couldn't that same situation happen then too?
Oh, sure. Oh, sure. So if you think about, when that first spouse dies, if he or she has children from a prior marriage, he or she, again, may want to provide for those children as opposed to everything going to the surviving spouse. That surviving spouse may then remarry, and again, he or she may have children from a prior marriage. So it's kind of just an extension of the same situation, whereby instead of leaving all of their assets to the surviving spouse, they may want to make sure the children, particularly children from a prior marriage, are taken care of as well, as opposed to just saying that after that spouse dies, because they may not be children of the second spouse to die.
There used to be a saying, he who grabs first gets first. But I remember one time, and these are very intelligent people, and the client said to us that she sees the children of her father's second marriage on the street after they die, and she's wearing her mother's jewelry.
Yeah.
And they weren't giving it back either. So maybe, like you say, they should do something ahead of time. Maybe.
Oh, absolutely. I mean, the best course of action is always to plan for these things in advance. We obviously preach that to all of our clients, but oftentimes it takes us, something happening either directly to people or indirectly to somebody that they know, before they take the appropriate steps. We wish we'd all plan well in advance before anything happens, but that isn't always the case. One of the things that second marriage also typically will bring up for discussion is the use of trust as part of a person's estate plan, because by utilizing a so-called living trust, which is simply a trust that's created during a person's lifetime, as opposed to a trust that's created in the person's will. So by utilizing a so-called living trust, you can provide the flexibility in that document to provide for multiple beneficiaries, whether they be children, grandchildren, spouses, children of a prior marriage, etc. And you have a lot more flexibility in that type of a document, as well as other benefits of utilizing a trust, than simply allowing for the assets to be distributed according to a person's will.
That's interesting.
Well, here's something that I'll throw a little more complexity into this.
Okay.
Because it's, you're specializing in elder law. So let's say the two people, they're still married, neither one has died yet, but one of them puts some of their property in a living trust for the purposes that you mentioned. And the thing, though, the threat is that one of them might have to go into a long-term care facility because of Alzheimer's or whatever it is.
Right.
So of course, those assets, unless they are wealthy enough and they they put away assets to cover those purposes, or they have long-term care insurance, those assets could be depleted. Could you tell us a little bit how that works, and about the having to go on to Medicaid and
Sure.
the assets of people who are well-intended?
Right, sure. So you mentioned that the other question was a loaded question. And of course, that question, Camille, is just as loaded with different issues, if not more. So when we get into the whole discussion of long-term care and how to pay for that care, of course, one of the options that sometimes almost becomes a default option is if the client can qualify for Medicaid, which in Massachusetts is referred to as Mass Health. So you'll sometimes hear both those terms, Medicaid and Mass Health, interchangeably. There are financial qualifications, there are medical qualifications. The advantage with a husband and wife, where one spouse may need to get onto Medicaid, is a husband and wife have the ability to make transfers between themselves of assets that are not subject to the so-called 5-year look-back period that Mass Health imposes.
Mhm.
So there's a lot more flexibility when you're trying to plan for the possibility of long-term care in financing that long-term care through Medicaid. There's a lot more flexibility when you're dealing with a husband and wife situation than with an individual.
Mhm.
We also, I mentioned the idea of a living trust for transferring assets in the case of a second marriage situation. It's also used, obviously, in many other situations. But when we talk about trust, it's really not one size fits all, and there are different types of trusts for different situations. And I mentioned the idea of a living trust being a trust that's created during a person's lifetime, but that's only one characteristic. We then get into whether a trust is revocable or irrevocable. And generally speaking, when we're dealing with the Mass Health / Medicaid situation, we're not utilizing a revocable trust, but rather we're utilizing an irrevocable trust.
Mhm.
And the main reason is assets held in a revocable trust are going to be considered countable towards the asset limits by Mass Health,
Mhm.
whereas assets in an irrevocable trust, so long as it meets certain other criteria, are generally not going to be considered countable for Mass Health purposes.
Mhm.
Keep in mind, an individual can only have $2,000 in countable assets plus their primary residence. A couple can have approximately $130,000 together plus their primary residence. So once again, you have higher asset limits, as well as what I mentioned before about the ability to transfer assets between spouses and not have those transfers be subject to a penalty.
Tell
Are you
me again
saying
what
that
you said about the
okay.
amount that in
Go ahead.
assets an individual could have versus the couple?
Right. So
Okay.
an individual can only have $2,000 in countable assets. So think of a scenario whereby you have an elder, maybe it's a surviving spouse, or maybe it's simply a single individual who never married, and that person has a home, and they've got a couple of bank accounts, depending on their situation. Maybe they're getting Social Security or pension, whatever the case may be. And that individual can only have $2,000 in what Mass Health refers to as countable assets. And basically, pretty much all assets that are available to the individual are going to be considered countable. Once again, the major exception to that rule is a person's primary residence.
Excuse me, but you're saying a couple can have 100,000 in countable assets?
They can have approximately $130,000.
But that sounds odd. Why would it not be close to 4,000? Wasn't it 4,000 at one point?
Yeah, no, there's no, you find out in dealing with Mass Health and Medicaid, many of their regulations are very difficult to determine what the rationale was behind them. But I think there's simply a benefit, if you will. Maybe we'll call it the marital benefit of being married. You get that extra amount of assets towards the asset limitation as opposed to a single person. So that's why I say it's very difficult for a single person if they don't plan in advance. So-called emergency planning or last-minute planning for an individual can be very difficult because once again, If they're not married, they don't have a spouse that they can transfer assets to get them out of their name, and they have the much lower limit of assets whereby they can only have $2,000 in so-called countable assets.
They have to produce a marriage certificate, right?
Well, it's maybe it's a way to encourage that folks should marry or stay married, and not get divorced if they're thinking that they might need to go into a nursing home.
We had a situation, and I think it all stemmed. I got to blame the city of Boston, where they lost the records. That some of the records for the certain year got destroyed. I'm sure everybody's had that. So they out went the marriage certificate. What do they have to do? It's a real case. It took weeks, months.
If you've never had the pleasure, and I say that tongue in cheek, of having to prepare a Mass Health application for somebody to get them eligible to receive Mass Health benefits, it's a daunting task. And it's not for the weak of heart, but things like little things like a marriage certificate can hold up an application, because with a married couple, you do have to prove that you're married.
Do you do that, Camille? Is that what you do?
Well, we have clients who are already on Mass Health, and we're interested more into the coordination between Mass Health and Medicare.
Mm-hmm.
So we have people who might be on Medicare and Mass Health, they're called dual eligible, and trying to figure out which one is going to pay which one is going to pay as primary coverage and which one is going to be secondary. And Medicare will be primary and Mass Health secondary.
Right.
But yes, we do have some clients who are on Mass Health.
So you would work with Barry.
Right, exactly. Right.
What about, the last time you were on, and I'm wondering if it's changed, this whole thing about they have to go in the hospital, and if they go in for observation, they can't get, if it's called observation, they can't get into a nursing home or a recovery home, and the medical criteria is different from the financial criteria. Now, that was 2 years ago. What, has anything changed since then on all that stuff?
Well, nothing has really changed in that regard, but keep in mind, picking up on what Camille just mentioned, when we're talking about Medicaid, we're talking about long-term care as opposed to Medicare, which is short-term hospitalization. Now, of course, many times folks are going from a hospitalization stay into sometimes it's a rehab facility on a short-term basis, but other times, because their situation requires that they're going from the hospital into a long-term care facility. Medicare is going to pick up that short-term hospitalization. Medicaid is the program for long-term care.
Interesting.
Yeah.
No, I don't know if we touched on life estates the last time, although I think we have. What's new in the life estate?
Maybe you can tell our audience what is a life estate.
Right. So sometimes, when we're dealing in the context of estate planning in general, and certainly with Medicaid in particular as part of estate planning, many times the person's primary residence is at the core of that planning. What to do with the primary residence in order to avoid the lien that Medicaid has. If a person goes on to Medicaid after they pass, Medicaid has a lien on that person's estate to get repaid for the amount of money that they paid for that person's care. And the lien can only attach to the so-called probate assets of that individual. So part of our planning and part of the objectives behind the planning is to try to set up their estate plan in such a way that when they pass, their assets are able to pass outside of probate as opposed to being a probate asset. It's the probate assets that the lien attaches to, not the non-probate assets. So many times, it might be we're utilizing one of those so-called irrevocable trusts, but another option to that is a life estate deed. A life estate deed is a deed whereby, as opposed to somebody giving their property to somebody presently, they execute the deed. It looks like a normal deed, but what they're transferring is the future interest in the property, and they're retaining the present interest. So, for instance, you might have a husband and wife situation, or an individual, and he or she has 2 or 3 adult children, let's say. Well, that person might execute a deed to their children, but again, retain a life estate in the property, or what I refer to as the present interest in the property. When that person passes, that property is going to pass automatically to their children as the so-called remainderment, and it doesn't have to go through probate, even though that is an individual holding title to that property in just their own name. Normally, an individual holding title to assets in their own name, those assets have to go through probate. But by virtue of executing a life estate deed, the property can pass to the children or whomever the intended beneficiaries are, and it doesn't have to go through probate.
So this is a common question too. So say that's true, and then the people have to go into a nursing home or the hospital. What's the story with their life estate then?
So, the life estate deed is a transfer, and assuming it was with the children, in all likelihood, there's no consideration being paid for that. It's basically a gift. So it is subject to the 5-year look-back period, and it would be considered a so-called disqualifying transfer if the life estate deed were executed within 5 years of that person trying to qualify for Medicaid. Okay, if they get past the 5-year period, then it's simply they hold the present interest in the property, but once again, assuming it's their primary residence, that's going to be a non-countable asset.
I know we're almost near our end. I have one question.
That goes fast, huh?
I know, doesn't it?
Yeah.
On the coronavirus, because this is like you seem to be doing almost the same and haven't let the coronavirus impede you at all. Have you had to file any papers in the court, and how has that been? Has that been?
One of the many ramifications to the virus has been that the courts, by and large, have not been open to the public until very recently, and so any filings have had to be done remotely, by email, etc. But I think one of the big things I think we started to touch on at the start that you are seeing is in the area of living wills, not to be confused with a living trust. A living will is a statement of one's wishes that if he or she was suffering from a terminal illness with no expectation of recovery, that they wouldn't want any so-called heroic or extraordinary measures used to keep them alive. And so what we're seeing is a lot of people being concerned about if they were to contract the virus, and if it were to turn into a terminal situation, where they're not expected to recover, having that document in place so that their spouse and or their children have something to go by, that's an indication of that person's wishes made at a time when they were healthy and competent, that they do not want any so-called heroic measures or extraordinary measures used to keep them alive.
So let's translate that into a situation where someone is rushed to the hospital ER because of difficulty breathing, COVID-19 symptoms.
Sure.
And the only way that they can be treated is to go on a ventilator. So
Right.
have you seen any situations where people who might become familiar with what it's really like to be on a ventilator and what it's like to, if you're lucky enough to survive it, which most are not.
Right.
Have you seen any situations where people are considering that aspect when they say heroic measures or not?
Right. So again, every case is very case specific, very fact specific. And it's obviously a very difficult situation for somebody to have to make. A lot depends on what that person's prognosis is, in what both their physical condition and mental condition are at the time, as to making that decision to have a person continue on a vent, or to take them off the vent. In sort of, I hate to use the expression a typical situation because they're really not typical, but if the way you described it, Camille, somebody's brought to a hospital in that situation, but they are otherwise relatively healthy. They have their mental faculties about them. That's probably not a situation where you're talking about taking somebody off of life support. We're usually more dealing in sort of a stroke situation, a head injury, brain injury, something where perhaps they're in a coma, or something of that situation where they can be kept alive, but it's a quality of life issue. And many times that's where the family is being asked to make a decision about, terminating life support or not.
Yeah.
Boy, guess what?
What?
It's time.
Wow.
Oh, my goodness.
Wow.
Wow.
That half hour goes by fast.
It
Well,
sure
doesn't
does.
it?
Yes.
Well, Camille usually thanks everybody.
Yes.
Yeah.
This has been great, Barry. Thank you so very
Yeah,
much.
Oh,
wonderful.
it's my pleasure.
We've only touched
Wonderful.
the surface, by the way. I mean, this
I
is
know.
the tip of the iceberg. So
You were
we'll
tough to
definitely have
get,
to have
but you
you
were
back.
worth it, huh?
Yeah, he's
You
definitely
Thank you.
worth
I
it.
guess.
Yes.
Mhm.
Yes. So to our viewers, thank you very much for watching this episode. And you may have more questions about estate planning for your situation. If you do, send us an email and we'll be happy to get Barry connected with you and have a little more of a conversation about it.
Yeah, he's
And
great.
otherwise, please remember to let us hear from you. If you have any other questions, if you have suggestions for other topics, we'd love to hear from you. Because remember, this is your show, The Law, Your Money, and
And
You.
you. And you, and you, and you. Thank you.